Justice Kavanaugh?
A couple things, just to talk again about the standard. I mean, getting the definition of for cause right, which we may not have to do in this posture, so I take that, is critical, because on the one hand, you have the independence of the Federal Reserve, which we've talked about. The other hand, we have people have committed, again, not talking about the facts of this case, but serious ethical or other wrongdoing, digging in and remaining in office. And it seems like your two answers to that, when you said your frontline positions, I&M, were intervention/resignation. And I'm not sure that really works with some people who are going to just dig in. You know, they're not going to leave. And then the other was impeachment, but of course, with the 2/3 requirement in the Senate and the time constraints of the House and Senate, I'm not sure that's available as often as you say. All of which is getting me to the point of, I don't see how the frontline position really can be the final position without making, kind of tilting the balance here too far the other direction from where the Solicitor General is. You just want to tackle that at all? I mean, you've covered it, but I want to get it out one more time so you can succinctly answer it.
Sure. I think the best thing that I haven't said already that I could add is, I think in the unique context of this particular agency, you want to strike the balance more in favor of keeping an official who maybe in a perfect world would be removed, because this is the opposite of the situation in essentially all of the other situations, with the possible exception of like the tax court and the court of claims and the court of military appeals. Here, I think it's less important that the president have full faith in every single governor, and it's more important that the markets and the public have faith in the independence of the Fed from the president and from Congress. And in this regard, I think this is not a situation where unlike Myers, which is the ultimate example, where the president's trying to arrogate some power away from the executive. This is a situation where Congress, political animals, one and all, knew better than anyone that the short-term temptations to lower interest rates and have easy money was a disaster in the long term, but was going to be irresistible. And so they tied their own hands by taking the Fed out of the appropriations process, and they tied the president's hand. And I think they tied the president's hand in a pretty significant way. And I understand the concerns about the balance, but I would say in this one context, it probably makes more sense to and maybe you want to bring in a little bit of common law, and that's fine with me, but I do think you want to strike the balance so that the ultimate imperative is that the markets don't think that rates are being lowered for political pressure. When rates are lowered, the markets are going to understand that that's actually prudent financial management of our monetary policy.
In your colloquy with the Chief Justice about what a hearing would look like within the executive branch with the president or with the president's designee, I just want to make sure I have this clear. In that hearing, you could make legal arguments as well, I assume, not just factual arguments, but legal arguments to say, we don't think this rises to the level of for cause. Basically, the kinds of arguments that you've made here, you could make to the president in the same way in an impeachment proceeding. People make legal arguments to the Senate about what exactly is high crimes and misdemeanors, correct?
Correct, and obviously the nature of the hearing is going to inform the scope for that. If it's just half an hour with the president, I don't know how much you're going to get into sort of legal briefing. But if you did do anything like Taft, or you just said, well, we got a couple of ALJs lying around, we'll have one of them just sort of hear the evidence on this. I mean, then I would expect there to be presentation on both evidence and law.
And just for the kind of simplest way, and this Justice Kagan was asking, to decide this case, I think one way would just be say there was insufficient process, and therefore we, at this juncture, deny the government's application. Thoughts?
I think that would be a very simple way to decide this case. I think perhaps the defect that was alluded to in the colloquy with the Chief Justice is that probably is also the way that probably maximizes the chances that it gets back here on the merits, whereas if you decided to go a little further and say something substantive, it might bring all of this to an end, and there's probably some virtue to that. Certainly there's some virtue to that from my client's perspective.
Thank you.